Here is a summary of the final decision of June 5, 2025. Laboratory Corporation of America Holdings v. Davis, case number 24-304. Please note that this summary is read by an automated voice. The Supreme Court wrote a per curiam decision that dismissed the case as improvidently granted. Justice Kavanaugh filed a dissenting opinion. I'll summarize Justice Kavanaugh's dissent and leave you all with some thoughts on the dismissal. The question presented in this case is whether a federal court may certify a class action when some of its members lack any Article III injury. The case arose when blind patients sued LabCorp over inaccessible check-in kiosks, claiming violations of the ADA and California's Unruh Civil Rights Act. The district court certified a class in May 2022 and then refined the definition in August 2022, creating competing orders that complicated the case's journey through the appellate system. The Ninth Circuit granted LabCorp's Rule 23F petition to appeal the May 2022 class certification order, even though the district court had issued a refined class definition in August 2022. After reviewing the merits, the Ninth Circuit affirmed the certification, ruling that Rule 23 permits classes that include more than a de minimis number of uninjured class members. This decision created the procedural confusion that later complicated Supreme Court review, as the Ninth Circuit had specifically authorized appeal of the May order rather than requiring LabCorp to appeal the August refinement. Here is a summary of Justice Kavanaugh's dissenting opinion. The court dismisses the case as improvidently granted and therefore does not decide the question presented, whether a federal court may certify a damages class pursuant to Federal Rule of Civil Procedure 23 when the class includes both injured and uninjured class members. The court presumably dismisses the case because the court does not want to tackle the threshold mootness question that plaintiffs have raised. In my view, however, plaintiffs' mootness argument is insubstantial. I would rule that the case is not moot and would decide the question presented. On the question presented, I would hold that a federal court may not certify a damages class that includes both injured and uninjured members. Rule 23 requires that common questions predominate in damages class actions. And when a damages class includes both injured and uninjured members, common questions do not predominate. Instead of resolving that important merits question, the court dismisses this case as improvidently granted. That is presumably because the court does not want to deal with plaintiffs' threshold mootness argument. To be clear, the court does not hold that the case is moot. Rather, the court simply declines to decide either the threshold mootness question or the important class action question on which we granted certiorari. Unlike the court, I would resolve those questions. In arguing that the case is moot, plaintiffs contend that LabCorp appealed the wrong class certification order. That is incorrect. Recall the sequence of events. In May 2022, the district court certified plaintiff's damages class, and LabCorp then filed a Rule 23F petition in order to challenge that certification order in the Ninth Circuit. In August 2022, the district court clarified the class definition. But in the August order, the district court stated that the order did not materially alter the composition of the class or materially change in any manner the original May class certification order. The August order did not purport to certify a new class. The Ninth Circuit subsequently reviewed and ruled on the May certification order. The Ninth Circuit did not treat LabCorp's appeal of the May order as moot. In September 2022, after the district court had issued the August order, the Ninth Circuit authorized LabCorp's Rule 23F interlocutory appeal of the May order. The Ninth Circuit later addressed the merits of LabCorp's appeal with respect to the May order and ruled in plaintiff's favor. In doing so, the Ninth Circuit issued a judgment adverse to LabCorp, and LabCorp properly sought certiorari to reverse that judgment. Still, plaintiffs seem to think that the May order was no longer in effect and was superseded by the August order. According to plaintiffs, LabCorp should have somehow appealed the August order. Under Ninth Circuit precedent, however, LabCorp could not have appealed the August order because only orders that materially change the original certification order qualify as appealable under Rule 23F. And the district court had explicitly stated that the August order did not make any material changes. Moreover, under the text of Rule 23F, a party may appeal only an order granting or denying class action certification. The August order did not grant or deny class certification as the district court indicated. So to challenge the class definition under Ninth Circuit law, LabCorp could appeal only the May 2022 certification order. LabCorp did so. LabCorp has proceeded reasonably in the District Court, the Court of Appeals, and this court. There is no barrier to this court's deciding the class action question presented in the context of reviewing the Ninth Circuit's judgment. On the merits, I agree with LabCorp and the United States as Amicus Curiae. Federal courts may not certify a damages class under Rule 23 when, as here, the proposed class includes both injured and uninjured class members. Rule 23, and this court's precedents make this a straightforward case. Rule 23 authorizes damages class certification only when common questions of law and fact predominate. A damages class consisting of both injured and uninjured members does not meet that requirement. As the government succinctly and correctly stated at oral argument, if there are members of a class that aren't even injured, they can't share the same injury with the other class members. The Ninth Circuit, nonetheless, approved plaintiff's class. Relying on circuit precedent, the court concluded that Rule 23 permits certification even when the class potentially includes more than a de minimis number of uninjured class members. The Ninth Circuit's decision is incorrect under Rule 23 in this court's precedents, and it will generate serious real-world consequences. Classes that are overinflated with uninjured members raise the stakes for businesses that are the targets of class actions. Overbroad and incorrectly certified classes threaten massive liability, here with potential damages up to about $500 million per year. That reality in turn can coerce businesses into costly settlements that they sometimes must reluctantly swallow, rather than betting the company on the uncertainties of trial. Indeed, the advisory committee notes to Rule 23, F. Warn, an order granting certification may force a defendant to settle rather than incur the costs of defending a class action and run the risk of potentially ruinous liability. That is one reason why Rule 23F's interlocutory appeal procedure was established in 1998. Importantly, the coerced settlement substantially raised the costs of doing business, and companies in turn pass on those costs to consumers in the form of higher prices, to retirement account holders in the form of lower returns, and to workers in the form of lower salaries and lesser benefits. So overbroad and incorrectly certified classes can ultimately harm consumers, retirees, and workers, among others. Simply put, the consequences of overbroad and incorrectly certified damages, class actions can be widespread and significant. I would resolve the question presented and reverse the judgment of the Ninth Circuit. I would hold that federal courts may not certify a damages class pursuant to Rule 23 when the class includes both injured and uninjured class members. I respectfully dissent from the court's order dismissing the writ of certiorari as improvidently granted. Analysis. What stood out here is the unexpected ending to LabCorp v. Davis. After granting cert and holding a full oral argument with some of the most distinguished attorneys in the country, the Supreme Court simply dismissed the case as improvidently granted. That's legal jargon for, we shouldn't have taken this case in the first place. Let's unpack what happened. The case revolved around a seemingly straightforward question. Can federal courts certify a class action that includes both injured and uninjured people? LabCorp, a diagnostic laboratory company, introduced self-service kiosks at their facilities, but these kiosks weren't accessible to blind patients. A group of legally blind individuals sued, claiming violations of the ADA and California's Unruh Civil Rights Act. The procedural history gets complicated fast. In May 2022, the district court certified a class of legally blind individuals who were denied full and equal enjoyment of LabCorp services. Then in August 2022, the same court issued another order that refined the class definition to include blind individuals who, due to their disability, were unable to use the kiosks. The district court specifically noted this refinement didn't materially alter the original class. LabCorp appealed the May order to the Ninth Circuit, which upheld the class certification. The Supreme Court then granted cert to decide whether classes with uninjured members could be certified. The oral argument showed many justices were genuinely interested in resolving the substantive question. Justice Kavanaugh questioned how one of the problems with an overly broad class being certified was that it would pressure defendants into settlements that are coercive and unfair. This concern later appeared prominently in his dissent. Meanwhile, other justices zeroed in on the procedural oddities. Justice Thomas immediately asked about jurisdiction over the May order when subsequent orders existed. Justice Sotomayor wondered if reviewing an inoperative order would be an advisory opinion. Justice Gorsuch noted the squirrely complication that the only order that the Ninth Circuit was reviewing was the May 12th order, and it specifically said, "We can't hear. We have no authority to, no jurisdiction over the August order." Justice Barrett explored the consequences if the court couldn't properly review the case. These procedural concerns ultimately won out. The court issued a one-sentence per curiam opinion dismissing the case, with Justice Kavanaugh writing a substantial dissent. The dismissal likely stems from what Justice Kavanaugh called the threshold mootness question. Essentially, LabCorp may have failed to adequately explain in the cert petition that there were competing class definitions or confusion about which order was properly before the court. What became moot in this case wasn't the underlying legal question, but rather LabCorp's appeal of the May certification order. The problem arose because of the two different orders from the district court, the original May 2022 order and the later August 2022 refinement order. The respondents argued that when the district court issued the August order refining the class definition, the May order effectively became superseded and therefore moot. Under a general principle of federal procedure, interlocutory appeals from superseded orders are considered moot because courts are supposed to review only live controversies, not orders that are no longer operative. During oral argument, respondent's attorney Gupta specifically argued, "The May order is before us, but it's inoperative. The August order superseded it and replaced it." Gupta contended that any appeal of the superseded May order was moot under standard legal principles. LabCorp countered that the May order was still reviewable because the district court had explicitly stated the August order didn't materially alter the composition of the class. From LabCorp's perspective, the August order merely clarified the May order without substantively changing it. However, during oral argument, Respondents' counsel Gupta highlighted LabCorp's inconsistent position on whether the August order was merely a refinement. When there was a fight about this order, they said this is no refinement at all. This proposed definition, the August definition, is broader than the existing one and clearly includes those who have no injury. Gupta argued that LabCorp regarded the original definition, as I said earlier, as too tethered to injury, because it was defined in terms of who was denied a full and equal enjoyment of services. The procedural quirk that made this especially problematic was that LabCorp couldn't simply appeal the August order instead. Under Ninth Circuit precedent, LabCorp could only appeal certification orders that materially changed the original certification order. But the district court had specifically said the August order made no material changes. This created a catch-22 situation that Justice Kavanaugh highlighted in his dissent. During oral argument, the respondent's attorney acknowledged in his opening statement, "I wish these issues had been fleshed out at the cert stage and perhaps we wouldn't be here." The court's decision to dismiss the case suggests the majority wasn't satisfied that the May order remained a live controversy after the August refinement. Rather than wade into these procedural waters, the court simply dismissed the case, leaving the substantive question about uninjured class members for another day. In class certification cases, mootness can arise when the original certification order gets superseded by a later one. The question becomes, which order is actually being appealed? Since federal courts can only decide live controversies, if the appealed order is no longer operative, the case might be moot. Let's talk briefly about Justice Kavanaugh's dissent. Justice Kavanaugh's dissent closely hewed to his oral argument questioning. In both settings, Justice Kavanaugh focused on Rule 23's predominance requirement, the rule that common questions must predominate over individual ones for a class to be certified. Kavanaugh argued that classes with uninjured members can't meet this requirement because injury itself isn't common across the class. Kavanaugh also emphasized the real-world impact of over-inclusive classes, writing that overbroad and incorrectly certified classes can ultimately harm consumers, retirees, and workers through increased costs, passed along by businesses facing massive liability exposure. The contrast between the dismissal and the substantive oral argument reveals something important about how the Supreme Court operates. Despite significant interest in the underlying legal question, procedural barriers can prevent the court from reaching the merits. This case serves as a reminder that proper presentation of issues at the cert stage is crucial, even when the court seems eager to address the substantive question during oral argument. That's it for today. When I prepared today's episodes, I noticed a few trends in the opinions. I'll try to put together an episode next week on this. Hope you enjoyed this episode. If so, please follow, share, and review.